Hi everyone.
Hi, ma'am.
So we'll wait for 2 more minutes for others to join, then we'll start, okay?
Ma'am, also I want to ask you, is the Partnership Act and Sale of Goods Act and the syllabus, ma'am?
Partnership and sale of goods are not there in syllabus. We have negotiable instruments and specific relief.
Specific relief.
Yeah, like
Okay.
last year, I guess it was changed. So that
Okay,
part we have. For which state you are appearing?
Karnataka, ma'am.
Karnataka. Yeah, I think that those two subjects are not there now.
Yes, ma'am. Yes, ma'am.
Yeah.
In Karnataka. I'm asking if it's there or not.
Yeah, it's not there. Okay, so last class we discussed regarding performance of contract, right? So when there is a contract between two or more parties, they basically promise to do something, right? There is a promise that I will be doing this thing and you do this thing, right? There is a promise and we need to perform that promise, right? So in last class we saw that by performing a contract or by offering to perform it, we can put an end to the contract, right? Completing the contractual obligations or making an offer to do that. So in today's class, we will be covering two things, chapter 5 and 6. Okay, so basically it's quasi contract and also consequences for breach of contract. So these two things are there to be discussed. So chapter 5, if you see, it is talking about certain relations resembling those created by contract. That means what? It is some kind of a relationship is there, right? Between the parties, there is some kind of a relationship, but it's not a contract. But what it is something that resembles to, like a contract. So it's some kind of a relationship between two parties that is similar to a contract, but it's not a contract in the, proper definition terms, right? That we need certain elements to be satisfied and all of that. So considering that it's not a contract, but again, that relation is similar to a contract that we have between parties. So what kind of contracts are these? These are quasi contracts. Okay, so it is chapter 5 that talks about quasi contracts, and it is what? There is some kind of a relationship, but again, it's not a contract that we have. So there are basically like 5 sections that we have in chapter 5 that talks about different like situations when it may happen. So we will just see what quasi contract is. So quasi contract is also known as implied contract or constructive contract. So why implied contract or constructive contract? Because see, it's not like, like there is no proper offer and there is no proper acceptance, but it's implied from the situation or from the, facts of the situation itself that we have a responsibility or a liability towards the other person. It might not be a proper offer, proper acceptance, proper consideration or things like that. But again, it's implied from the situation that there exists some kind of a relationship. So it's also known as implied contract, or it's also known as constructive contract. There is no proper offer and acceptance, but what we find out from that situation is that there exists some kind of a liability of the parties towards each other. So it's known as quasi contract, implied contract, or constructive contract. You can just remember that it's chapter 5 of Indian Contract Act, and there are basically 5 sections that we have with regard to this. So anyone remembers which section defines contract? Definition of contract?
Ma'am, section 2, I don't know. It may be section 2.
Yeah, section 2 only. Which clause?
2A only, ma'am. A or B?
Is it H?
Yeah, it is H, not A and B. A and B is starting only, right? Proposal and all it defines. So it is 2H that defines what is a contract. So okay. What is the definition of contract based on 2H? Anyone remembers? Very simple.
An agreement enforceable by law.
Yeah, an agreement enforceable by law is a contract, right? So this is the definition section. 2H of the Indian Contract Act defines what is a contract. So what it is an agreement enforceable by law. So basically we should be able to enforce it by law, then only it becomes a contract. So enforceability of contract, right? That we are entitled to go to the court, ask for legal help to, make the other person perform his obligations. From where it comes? It comes from certain essential elements, right? We discussed the elements that we need for formation of a valid contract. So these are the elements that we need for formation of a valid contract. Only when these elements are satisfied, only when we have a valid contract between the parties, we can actually go to the court and ask for, enforcement of our rights under law. So what we need for contract, it should be enforceable by law. How it will become enforceable? Only when it satisfies the essential conditions, like offer and acceptance, there should be consideration, parties should be competent, there should be free consent, consideration and object should not be lawful, and it should not fall under the the list provided, which would be contract specifically declared as void. So only when all these conditions are satisfied, we can actually go to the court for enforcement of our rights. So what in general, what is it? Agreement means what? Offer and acceptance, right? It may be one person asking whether you want to go out for a movie with me, the other person saying, yes, I would like to go. That also would become an agreement. There is offer, there is acceptance. So offer and acceptance will make it an agreement. But again, that is not enforceable, right? Only when it's enforceable, it becomes a contract. So agreement is what? Offer plus acceptance. It may be just any random promise also, right? Accepting a dinner invitation to, accepting, agreeing to go out for a movie or something like that also. But only when it is enforceable, only when that consideration is having some value in the eyes of law, we can actually say that, okay, fine, this is a contract. We can go to the court for its enforcement. So in general, what we need is that we need offer plus acceptance, and then we need its enforceability. Only then it becomes a contract and we can go to the court. But there are certain exceptional cases where there might not be an offer, might not be an acceptance, or other conditions may not be there. But even then what happens is that it will be enforceable by law. So what kind of contracts are these? These are called as quasi contracts, where it may not fall under that proper definition of contract, that parties should be competent, there should be free consent, offer, acceptance, and all of that, right? Those conditions might not be satisfied, but even then we can go to the court and validly ask for performance of that contract. So these would be considered as quasi contract. So basically you can remember that for offer, for a normal contract, what we need certain essential elements to be satisfied. Then only it becomes enforceable, then only we can go to court. But there are certain exceptional cases where even without, presence of proper offer, proper acceptance, and all the other conditions also, we can go to the court. So these are considered as quasi contracts or implied contracts or constructive contracts. So that is what today we are going to discuss, what these type of contracts are basically and how can we enforce these types of contracts. So what we need is that for, a valid contract, we need agreement, right? Offer and acceptance we need. But there are certain things where we do not need it. There, it do not originate at making an offer, accepting the offer, having consideration and all of that. But still we will have that, and it is based on the principles of equity. So this concept, this entire concept is based on the principle of equity, that no one, everyone should be getting proper benefits, right? We cannot, something should not be unjust. One person is gaining some benefits, another one is losing out on things. So it should not be like that. So this concept is based on the principle of equity. And you can just remember that what are quasi contracts? It do not fall on under the traditional definition of contract, that offer and acceptance and other elements should be there. Then it becomes enforceable, then it becomes contract. It is something different from that. So is this part clear? Introduction part. What is quasi contract?
Yes, ma'am.
Yes, ma'am.
Okay, so we will look at the, like the sections and all. So if you have any doubts at any point of time, you can just tell, okay? We can discuss that. Okay, so now we will see the definitions, like the provisions, okay? So what quasi-contracts are basically do not fall under the traditional definition of contract, and we do not need to satisfy all the conditions that we have, all the essential elements that we have. So this is based on a Latin maxim, which means no man should grow rich out of another person's loss. So it is based on the principle of equity, right? That one person should not be getting unfair advantage and another person should not be losing out, right? It should be fair for both the parties or both the sides. So it is based on this principle only, that one person should not be getting unfair advantage or unfair benefit from any situation or anything. But what happens is that both the parties should be at the same page, right? One person should not be losing out, another person should not be wrongfully gaining something out of a contract or out of a situation. So it is based on a principle called as unjust enrichment. So what is unjust enrichment? It's very clear from the term itself. Okay, what is unjust? Anyone? What is unjust?
Unfairly, like he didn't have any rights over it, but he made the most out of someone's loss, or something not fair.
Yeah, something not fair, something not, like not justified. And enrichment?
He has like enhancement has happened because of that reason, because of that unfairness.
Yeah, enhancement in his maybe present situation or present things, right? It may be like becoming rich or becoming more rich. So whatever was his present situation, in that some enhancement has happened. That is unfair or unjust for the other person. So you can just remember, it's very like evident from the term itself. It is unjust enrichment. What is unjust enrichment? It means that it is unjustified, right? And in an unjustified way, one person is gaining some kind of an advantage. So the liability in case of quasi-contractual relationship is based on this particular principle only, which means that no man should get unjustly enriched at the cost of another person's loss. That means one person should not be losing out and another person should not be getting some unfair advantage out of that particular situation. So no person should be gaining anything unjustly. When he is gaining such a thing, may like cause some amount of loss to another person. So one person on one hand is gaining something which is not fair on his part, and another person is losing out because of that situation. So that should not happen. And to balance that out, we have something called as quasi contract. So even though it's not a proper contract having offer and acceptance, we still consider it like a contract, and we will still make the other person perform his part or like fulfill his obligations, just to ensure that someone else is not losing out because of that situation and he is not getting any benefit, unfair or unfair advantage out of that particular situation. So this is basically the principle based on which this concept is we have. So there are like certain elements that we have. First is that one person is gaining some kind of a benefit, right? How this enrichment is happening? It is by getting some kind of a benefit, that I am getting some kind of a benefit because of a situation or from some person. How it is happening? At the expense of the plaintiff. That is, the other person is like losing out on that thing. Because I'm getting benefit, the other person is losing out on that thing. And how it is happening? It is unjust. That is, it is not justified for me to be gaining advantage or benefit out of that situation because someone else is losing out on something. So basically these are the three things. Firstly, there should be some benefit that I'm getting. That benefit should be at the expense of the other person losing out on something, and it should be unjust. That means it should not be, it is not something that I'm entitled to, I'm legally entitled to. and it is at the cost of the other person losing out on certain things. So you can just remember it is unjust enrichment. Sometimes question may come, okay, I saw one question where it was mentioned unjust enrichment. So you can just remember what it is, that no man should be getting any unjust advantage or benefit out of a situation where someone else is losing out because of that thing. So based on this principle only, the concept of quasi contract has been established, where we do not have a proper offer, acceptance and other elements are not satisfied, but even then we would consider that this is a type of contract and the parties are bound to perform their part. So it is what? Certain relations resembling those created by contract. So it is not contract, but it is something that resembles to a contract, right? Resembles to the obligations that we have under a contract. So it resembles to them, but it's not a proper contract in the proper like traditional definition term, right? That all these elements should be satisfied and all of that. So you can just remember that quasi contracts are also known as implied contract or constructive contract. Try to remember these three words, okay? Sometimes question may come like constructive contract they might mention. So if you know the different terms, it would be easier for you to understand that, okay, fine, they are referring to quasi contract only, or they are referring to implied contract and constructive contract only. So in general, we need to satisfy all these conditions, but here that is not necessary. Why? Just because we do not want someone to gain some unfair advantage out of someone else's situation or position, and someone else is losing out on their rights or something that they are entitled to. And three things we need. First of all, I'm getting some benefit that is at the cost of someone else losing out, and thirdly, it is not justified, right? It is not something which is justified based on the situation. So there are like 5 sections that we have. We will just go through the provisions, okay? What these sections are, and what are the different types of situations that are mentioned here. So first one is what? First one is claim for necessaries supplied to person incapable of contracting or on his account. Now, first of all, we know that a person should be capable of contracting, right? He should be of sound mind, he should not be a minor, and all the other conditions that are there, those should be satisfied for a person to be entitled to contract, right? He should not be like this entitled from contracting under any law and all of that. Those things should be satisfied. But here what they are mentioning is that even though a person is incapable of contracting, right? Even though that person is not capable of making a contract under the provisions of Indian Contract Act, still what happens is that the other person can claim what? For necessaries supplied to the person. If I am supplying some kind of necessaries to a person who is otherwise not capable of contracting, even then I have a right that I can claim for compensation, right? Claim for whatever expenses I have incurred, I can claim that, and I can say that I should, I should be getting those I should be compensated for the expenses that I had to incur just to supply those necessaries. Now this implies for that particular person, okay? It implies to person who is incapable of entering into a contract or anyone to whom he is legally bound to support. Take for example, there is one person, okay, A, who is of unsound mind. Now in general what happens, that person is not entitled to enter into a contract under the provisions of Indian Contract Act, right? That the person is of unsound mind. But what happens is that this person is of unsound mind and he is having, take for example, a son, okay? He is owner of few properties and father of a 7-year-old son. Okay, now what happens? A is a person of unsound mind. That means otherwise he is not entitled to make a contract. he is owner of a few properties and he is father of a 7-year-old son. Now, because he is of unsound mind, might be the person would not know that he need to get his son admitted to a school and provide him all the other facilities that should be given to a child. The person might not be aware about all of those things. So take for example now B, another person who is maybe a neighbor, who is a neighbor of A. What he does is that he gets the son admitted to a school, okay, admitted to a school, and also provides all the other necessaries, right? Maybe buying uniforms, buying books, copies, and all of that he does. Maybe he also gets him admitted in some co-curricular activities and all of that, also supplies some groceries and all of those daily needs. Now in that case, what happens? This person, right, A, he is of unsound mind, but otherwise he is owner of certain properties. He can incur the expenses, right? He can pay for the expenses of his child, like child's education. So in this case, what B can do is that he can file a case to claim, that he, whatever expenses he had to incur to get the child admitted to a school and all the other things, he can say that I should be compensated for that. Why? Because this person A, he is otherwise entitled to pay for his son's education, but he is not mentally sound, or he is not able to understand that it's important to get his son admitted to a school. So that does not mean that he will not even pay for the expenses, right? Because he is having certain properties, he is owner of certain properties. So B can file a case saying that I should be compensated for whatever expenses I had to incur for it. But again, B cannot be saying like, I took leave for 3 days from my office and all of that, so I should be also getting this much amount of interest or all of that. Those things should not be there, but whatever expenses he had incurred, those things he can validly claim from the person, because the person is having enough resources to pay for it. So it may apply that B is supplying something to A, the person who is of unsound mind, or he may be supplying something to other persons who are dependent on him. 7-year-old son, obviously he is dependent on the father. So anything is done for the son, for that also it can be, it can be asked from A's property or whatever assets he is having, from that we can be claiming it. So if B is supplying anything like that, then it can be claimed from the assets of that particular person who is otherwise not capable of performing or entering into a contract. So now what is necessities, right? That necessities word is not being defined under Indian Contract Act. It may mean a lot of different things also, right? Based on the situation. So what is basic necessities? We can say whatever we need for our existence, right? For our, like a reasonable existence. Obviously, we would need education. We don't need education to survive, but obviously we would need education to live a better life, right? So education also we can include the normal things like food, shelter, clothing, and all of that also. And depending on the situation, it might it might include a lot of other things also. Might be depending on the present situation, supplying sanitizers, or supplying so some kind of immunity boosters, or some kind of vitamins, tablets, or any other things, right? That also might be a necessity depending on the situation. So what is necessity? That is not being defined, but it may be something which we need for a reasonable existence. It may mean different things based on the situation, based on where we are residing and all of that. For a certain place, might be providing internet facility, having a laptop, having a phone, that might be a basic necessity. For certain other remote places, it might not be a basic necessity. But now, considering schools and colleges are closed, it might be a basic necessity. So what is this necessities? That is not being defined, and it might mean different things. So we can just think that, okay, fine, whatever we need for a reasonable existence, that is only a basic necessity. So it might mean different things for different people, different age group, different locations, and all of that also. So why in this particular situation, right? In this particular situation, there is no contract between A and B, right? A has not said that, okay, fine, I'm, like I'm mentally retarded, so you take care of my son, I will pay you from my property or something like that. There is no offer, there is no acceptance, there is no proper contract or agreement between the parties. But still what happens, it is something, right? This situation is something that resembles to a contract. One person is doing something for the other person's benefit or for the other person's well-being. So obviously there is something which resembles to a contract, but again we do not have a proper offer, acceptance and all of that. So this also courts might consider as a contract, and court might say that, okay, fine, this person is entitled to pay for his son's education, so he should be paying his neighbor B from his assets. Whatever assets he is having, he should be paying from that or things like that. So this is like the first provision that we have, that claim for necessaries supplied to a person incapable of contracting or on his account, maybe to the person who is incapable or to anyone who are dependent on that person, right? To them also it might be supplied, and for that he can say that I should be repaid whatever expenses I had to incur to provide for these things. Now it might even include a minor, otherwise minors are not capable to like enter into a contract, but certain things are provided to a minor and minor is owner of a certain property, then from that also the person can claim for it. Otherwise no one would help others, right? They might think that, okay, fine, I cannot even claim for this, even if I like get this 7 years old son admitted in a school, he might, no one would come forward to help, right? So these kind of provisions are mentioned so that there is like equity also. One person is not gaining unfair advantage, right? Just because he is of unsound mind, even if he is having multiple properties, we are not giving him any advantage. He is still paying for the expenses of his son's education, but he is not able to do it, so someone else is taking care of that. But he should not be getting unfair advantage, and this neighbor should not be losing out on like providing education to this particular child. So this is the first one, claim for necessaries supplied to a person.
What relief is available to the person if the person of unsound mind, if he does not have enough property to pay for the supplies, but somebody has actually helped him or generally paid for something, and he's generally bankrupt or he doesn't have enough money? So what relief is available to the person?
Yeah, in that case no relief would be available. It is only when the other person is having the like enough resources to pay for it. If a person is like bankrupt, or if a person is of unsound mind, he's not having any properties also, then obviously the person is not having any source of repaying, right? So in that case no relief would be available to the person. But in case he is having, that case we are considering that he is having enough properties, so he should not be getting the advantage. But if he is not having any property, no resources or anything, might be someone would come forward and get the son admitted or something like that. So again it depends on the person whether he wants to continue with that or not, whether he wants to continue paying school fees, tuition fees or not. If not, he can skip that. If yes, he can go forward with it, but obviously there is no option to repay, right? The person is not having enough resources, so no relief would be available in that case.
Ma'am, what is the benefit for a supplier?
Your voice is not clear. What?
What is the benefit for a supplier?
What is the benefit for? Supplier.
Who take care of.
Okay, there is no benefit as such. See, if one person knows that, okay, fine, my neighbor is of unsound mind, he's having a child of 7 years of age, and he's just sitting at home. So he might feel that, okay, fine, he should get admitted in a school. He should also, like study, he should also learn. So there is no benefit as such, but just as a moral responsibility, he might get the other person admitted in a school. There is no benefit as such for the person, but out of goodwill, he might, like want to help a person who is not having any other source of any other help or anything like that. So we are not considering about the benefit. There is no benefit as such, but if I'm doing something out of my moral responsibility, it's not like I am losing out on my things and the other person is gaining advantage. If other person is not having enough resources, obviously I will not be paid. But if he is having enough resources, in that case, he should not be getting unfair advantage and I should not be losing out. That is the main point here, that it should not be, like unjustified for one person, that the person is paying, this person is having enough resources, but still he is not paying for the expenses or things like that. So in that case, just to make things equal, make things fair for both the parties, court might say that, okay, fine, you should be paying for, like you should be repaying the amount or repaying the expenses. Is this section clear?
Yes, ma'am, it's clear.
So first one was for persons who are incapable of contracting, right? Second provision that we have is with regard to reimbursement of person paying money due to another in payment of which he is interested. That means here we are not saying that the person is incapable of contracting. But what we are saying is that he is having a responsibility, he is not performing it. So someone else is performing that responsibility. Now this other person has a right that he should be repaid from this person. So we will take one example that will make things clear, okay? Take for example, one person A is the owner of a property. Owner of a property. And he has mortgaged that particular property for a certain amount of loan, okay? Maybe like an amount of like 30 lakhs or something, and he has repaid almost that amount, just 1 lakh is remaining. Okay, so one person A is owner of a property, he mortgaged that property for a loan of 30 lakhs rupees. He has repaid 29 lakhs, only 1 lakh is remaining. Okay, now only this amount, last installment, is remaining. At that point of time, what he does is that he makes a lease agreement, okay, with another person. So he just makes a lease agreement with another person and says that you can, like stay in my property and you can just pay me the amount. So he just takes maybe some amount of 80,000 rupees he takes, and it is for like 11 months lease, okay? 11 months lease. Now this already agreement is done and everything, and he gave his property on lease to B. Now what happens? B started his business in that particular property. He invested on that property and he started with his business. Now after 1 month, what happens is that after 1 month, some notice comes to him that this property was mortgaged and this amount is not been, paid or something like that. So we will, we will proceed with, we will take this case forward in court. So now what happens? We do not want his business to be affected because he has already invested on that property, right? So just in order to avoid any kind of consequences, right? Any kind of legal problems or anything like that, he says that, okay, fine, I'm paying this 1 lakh rupees to you. In that case, what happens? B has paid this 1 lakh rupees, right? But it should not be B who is paying it, right? It should be A who should pay it. So in this case, B can file a case for recovery of this 1 lakh rupees. Why? Because this payment of 1 lakh rupees, it is what? It is due by another. It is A who should be paying it, but A is not paying it. So B has paid. Why? Because he is interested in the payment. Why is he interested in the payment? Because he wants to avoid any kind of legal, any kind of litigation or anything like that. So he has paid the amount, but it's not B who should be paying it. So B can later on claim for, recovery of that 1 lakh amount, saying that it was not me who was bound to pay for this amount. So in this case also, A should not be getting some kind of unfair advantage. First of all, he has mortgaged the property. During that time, he should not be leasing out that particular property. If he is doing it, again, the other person is paying for it. So A should not be getting benefit, right? Unfair advantage. And B should not be losing out just because he was not aware that this property was mortgaged for a certain amount of loan and loan is not cleared or something like that. So it should not be done like that. One person should not be getting any unfair advantage because of this situation. So similar type of example, another example we have where this lease was granted by a jamindar and he was not paying some kind of like revenue payment that was pending from his part. So government sent an like a notice that we will be auctioning this particular property. So just in order to prevent that, one person, the person who was staying there under that lease agreement, he said that I will be paying to the government. So the other person, right, owner should refund or repay that particular amount so that this leasee is not losing out by paying this particular amount. So it basically involves where I am bound to pay a certain amount legally. I am not paying it. Someone else is paying on my behalf because this person is interested in the payment. This person has got something to do with that particular property or maybe goods. So he is paying it. Now he should not be the one who is paying it. So I will have to refund or return that amount to the other person just to ensure that he is not losing out. Again, here also we do not have like a proper contract, right? Offer, acceptance and all of that is not there. But still we would consider that it's something similar to a contract and the parties should be like refunding the amount. The other person should not be losing out on his, any kind of, you know, like profits or anything like that.
Does this case also work for the guarantor in a loan? Because in case the loan, there's a defaulter by a loan, the guarantor is bound to pay the loan. Is he bound to also recover from the defaulter?
I don't think guarantor would be bound because it is basically like parents or someone like relatives and all only would be guarantor, right? Maybe like a child is taking an education loan, parents are guarantor. So in that case, so parents are basically saying if my child is not getting a job after his education, I will be paying it. So again, parents, I don't think, you know, like parents would go against the son and then recover the amount or something like that. Because it is again something that they are doing, you know, like willfully they are doing it and without any consideration or things like that. So they are doing it just so that their, you know, like son gets that particular loan. And in that case, again, we have a valid contract, right? So this is basically where no contract as such is there. The party is not anyways, you know, like a leasee is nowhere related to that particular mortgage agreement that was there between the parties. So in that case, it would be applicable where there is no such contract or no such agreement is there, but still the party is, you know, like paying it because he is interested in that particular payment because of any particular reason.
Okay.
So first of all, what we need is that one person is bound by law, right? Being owner of the property, he is bound by law to pay it, but he is not paying, someone else is paying. Why? Because this other person is interested in the payment. Okay, so this was about section 69, where again we don't have any kind of contract, but still we can make the persons liable. Okay, next is obligation of persons enjoying benefit out of non-gratuitous act. So something which I am doing, right? I am doing something for another person, but I am not doing it for free, right? I am expecting some kind of a maybe I am expecting some kind of a payment or something like that in return. So if there is anything that I am doing where I am not doing it for free, but I'm expecting some kind of a payment, in that case also the other person should pay and you know, like should pay for this. Okay, so we will see the provision. So it says when a person lawfully does anything to another person or delivers anything to him, not intending to do it gratuitously, and such other person enjoys benefit thereof, the latter is bound to make compensation to the former in respect of it or restore the things done or delivered. So take for example what one good example would be like in a railway station, suddenly a coolie comes and he picks up your luggage, and you also do not stop him. He just picks it up and then he takes it to the like taxi stand. In that case, what happens? Obviously, the coolie is not doing something for free. Even though there is no proper offer, acceptance or things like that, definitely he is expecting money from you, right? He is expecting money for the service that he has provided. So in that case, even though there is no proper offer, acceptance or things like that, there is a contract, there is something that the other person is doing, and he is expecting some kind of a benefit from you. He is not doing it for free. So you will be bound to, like compensate the person for whatever, or you would be bound to make that particular payment. So same example would be, take for example, so like a tradesman leaves certain goods at someone else's house by mistake. So this person, right, other person B, obviously he will have the knowledge that these goods do not belong to me. Even if he is enjoying it, he will be bound to pay for them. Then again, in another case, we can say, right, like the present situation, okay, one family, they are confined inside a house because of corona. What happens is that their house help is there. So house help feels that, okay, fine, I know whatever things they need, right? Whatever are their necessities, whatever things they would need, I know all of that. So I will be supplying those things to the family. I will be buying those things and I will be giving those things to the family. So in that case also, obviously, house help is not doing it for free, right? House help would expect that whatever expenses I have incurred during this time of 2 weeks, I should be repaid that particular amount. So if house help has incurred like 10,000 or 15,000 rupees of expenses, she can file a case for recovery of that. Why? Because whatever she was doing, she was not doing it for free, but she expected that whenever situation becomes normal, I will be repaid the amount or the expenses that I have incurred in order to provide for it. Again, another example might be like someone orders something online, okay? And another person is there, by mistake he takes the delivery of it. So obviously we would expect that the other person pays for it or other person returns the benefit or things like that. So same example might be applicable in many cases. You can remember that coolie thing only. He picks up your luggage and he like takes it to the taxi stand. He is expecting money from you. Same might be the case. Maybe you are wearing your college uniform, you are standing at a bus stop, someone like a person comes with like a public vehicle or something like that, and he says that I can drop you to this particular place. Obviously it's a public transport, so obviously he is expecting that you will pay the fare, right, bus fare or whatever it is, you will pay for it. So in that case also we can say, right, the other person is not doing it for free. He is not interested in dropping you to your college, but he is interested in the money that you will buy a ticket and you will pay for the price. So in those cases also we can say that the person is doing something, but he is not doing it for free. He is expecting some kind of money or some kind of, he should be compensated for it. So it is basically applied when the other person enjoys the benefit, right? The other person is enjoying some kind of benefit because of this particular right. So there was this case also where one person, right, he like made some kind of an additional construction to the building. So he was constructing his building, he constructed something in addition to that, and the other person was enjoying benefit because of this. So obviously he will expect that you will pay for the expenses that I have incurred. Maybe we can take the example like one person was constructing his house, the other person maybe his like gate, he wanted to repair his gate or he wanted to repair one of his walls or something like that. If his neighbor did it, he did not do it for free. He will be expecting money for the labor cost and all the materials that he has used. So in such cases, the other person will have the liability to repay for it, because he would also know that obviously the person is not doing it for free. So because he is enjoying some kind of a benefit at the expense of the other person. So in that case also, he will have to repay or compensate for whatever expenses the other person has incurred. Next section is responsibilities of finder of goods. So a person who finds goods belonging to another and takes them into his custody is subject to the same responsibilities as a bailey. So in case of bailment, what happens? There will be two persons, right? One is owner of a property or owner of certain goods. Another one is the other person, right? Owner will deliver something to this other person because maybe he wants to get it repaired, servicing done or something like that. So this person will have certain responsibilities to take proper care of those goods. So same thing will happen in case a person finds someone else's good. So he also will be under same kind of responsibilities or obligations like a bailey, that he need to take care of goods of the other person and all of that. So this is with regard to section 71. So maybe the whoever finds goods, right, he will be under a duty to take reasonable care of those goods. Then, you know, like he should not be just start using those goods for his own purpose. He should not he should take like reasonable efforts to find the owner of those goods, right? Maybe if I find a wallet of someone, what I should be doing, I should take care of that wallet. I should not just throw it in middle of the road. What I should do, maybe I will open the wallet, I will look for some kind of address, phone number, or any kind of reference if I get regarding the owner, right? So I should try, or I should make an effort to find out the owner. If I get some phone number or something, maybe I will call that number and I will try to find, or you know, like connect with that particular owner. So when I find certain goods, what I have certain responsibilities. It's not like I found a wallet, I just start using that particular money which is there inside that particular wallet. What I should be doing, I should make an effort to find who is the owner of that particular wallet, and also I should make an attempt to return it to the owner, right? And I should take proper care of it also. I should not just throw it. What I should be doing, I should maybe make an effort to look for that particular person. But there are certain things, okay? Take for example, so what I have a right to retain those goods until and unless I am compensated for any loss that I have suffered to find out those things. Maybe, what example can we take? Okay, just take an example that like, it's not like a practical example, but just take this as an example. Maybe in middle of the road, one like vehicle was there and I had to pay to the traffic police to get that vehicle, you know, like moved from that particular place. Now in that case, what happens? Maybe I will ask the other person that you should compensate for whatever expenses I have incurred. Or maybe another example, what can we take? Maybe just normal example we will take. Okay, again, this is not like a very practical example, but still, someone was playing near my house and their ball just, you know, like broke my glasses of a window. So what I can do is that I can keep that particular ball unless and until I'm paid for the loss that I have suffered, right? It may be applicable for any other cases also. Maybe someone's like two people were fighting and one person just threw his phone and it broke the mirror of my vehicle. So I can claim that I will not give you your phone unless and until you pay for the loss that you have caused to my vehicle, right? So that would be one good example, that unless and until you are paying for the loss that I have suffered, I will not be returning you your phone. So that also would be an example. Or so what happens is that in general, I'm having a responsibility that I straight away do not start using that particular thing, but I make a proper effort to find the original owner and return it to the owner. But in certain cases, what happens is that in certain cases, maybe the goods are perishable. So in that case, I will have, maybe it would be justified for me to use it. Maybe if someone finds like a pack of ice cream or something like that, that is perishable, right? I cannot be waiting forever. Maybe a pack of fruits or something like that. I cannot be waiting forever for the owner to come and collect it. Maybe at that particular moment, I will make an effort. I will look around, ask people who is the owner, if someone left it by mistake or something like that. If I'm not able to find the owner, maybe I can start consuming it also. So in that case, it would, there is a chance of immediate damage, right? Because those goods are perishable. So that would be an exceptional case. But otherwise, whenever I'm finding some goods without an owner, it's my responsibility that I take care of those goods, and also I make a genuine effort to find the owner and then give that particular goods to the other person. And if I have incurred some kind of expenses to get those goods, then I can ask for refund of that particular expense as well. So this is applicable when a person is finding some goods without a owner. So his liabilities or obligations would be similar to that of a bailee. He will be under some obligations. He will be under some obligations or under some liabilities. Okay, so is it clear till here? Any section is not clear?
How can we exactly differentiate between section 68 and 70?
Section 68 and 70.
Because unnecessary goods and even it can be done in non-gratuitous way also. That's a little confusion.
Incapable of contracting. 68 and 70. Which two sections you are saying? 68 and 70, is it?
68 and 70.
Okay, so 68 is with regard to necessaries supplied to a person who is incapable of contracting. It might be getting a son of a person of unsound mind admitted in a school. So in that case, I have a right to ask for compensation for that. But in this case, it is just obligation of a person enjoying benefits out of non-gratuitous work. So in this case, we are not saying that the person is incapable of contracting. The person might be capable of contracting, but what we are doing is that there is no proper contract as such. So in this particular case, it might be by mistake I left something, by mistake someone delivered it to a wrong address, or it might be something that we are doing. Might be this example only you can take, right? That this family, right, they are confined inside a house. They can even order things online, right? It's not like they are incapable of contracting. They can even order their groceries and all of that online and get that delivered. But what this maid is doing is that she is voluntarily coming and providing all of that to the other person. So basically in section 68, it's like the person is incapable of contracting, but in 70, the person, we are not saying that the person is incapable of contracting or something, but just that there is no contract as such. The person is coming and doing it voluntarily, but again, she or he is expecting something in return of that. They are not doing it for free. They are not doing it like that. Might be they are doing it to help the other person, but again, they are expecting some kind of a money or some kind of a payment with regard to that. It may be what example can be? Maybe
Got it, ma'am.
yeah, you got it, right?
Yes, ma'am. Yes.
Yeah. So might be I'm not at my place, my neighbor is there, and some online delivery guy comes and he feels that, okay, fine, maybe he is also from that family only. He is also a member of that family. He just delivers it to the other person. So obviously I will expect from my neighbor that he either gives me that parcel or he pays for it or something like that. So basically the person is not like he is not capable of contracting or something, but he's just doing something and he is expecting money also in return of that.
Also, that 68 is specifically dealing with necessities, but then this other section does not specifically mention necessities. It can be any kind of benefit.
Yeah, right. Yeah, good difference. 670 can be anything. It's not necessary. It might be something that one person just, like wants to have. It's not necessary. Yeah, good point. 70 is not with regard to necessaries. So 71 is regarding responsibilities of finder of goods. So he again has certain responsibilities just like a bailee. Next is 70. So liability of person to whom money is paid or other things delivered by mistake or under coercion. A person to whom money has been paid or anything delivered by mistake or under coercion must return it. So in this case, what happens is that by mistake I am doing something or under coercion I am doing something, right? That the person is giving a threat that I will commit certain kind of an offense which is mentioned under IPC, or maybe under some kind of a mistake I'm doing. So in general, what we have seen is that mistake of law is not excused, but right? But in this provision, what happens? It includes both mistake of fact, also mistake of law. Also, there were cases where even though a person was not aware about a law, even then he was, like the other person was asked to return the benefit. Why? Because it was said that it was basically a mistake and you should not be gaining unfair advantage of it. Like based on the situation, it was unfair that we allow this person to keep all the benefits. So it was said that even though it's a mistake of law, we are not excluding it. So under section 72, mistake of law may also be included. Even though it's mistake of law, one person is gaining unfair advantage, even in that case also court might consider, if it feels that it would be unfair, that we allow the other person to be taking the benefit. So section 72 is what? It is basically liability of person to whom money is paid or other things delivered by mistake or under coercion to return those things. So one example we can take. Okay, so example we can take A and B jointly owe 100 rupees to A. So jointly they owe, right? It's like 50 rupees, 50 rupees. They need to pay to C. So what happened is that A made that payment of 100 rupees to C and B was not aware that this amount is being paid. So he again paid another 100 rupees to C. So in this case, what happens? C is bound to return that particular amount, right? Because he is not entitled to 200 rupees, but by mistake of these two parties, he was paid 200 rupees. So he should return that 100 rupees that was paid to him extra. Why? Because it was under some kind of a mistake. He is not entitled to that another 100 rupees, but it was by mistake only. So that should be returned by him. Another example will be a railway company refuses to deliver certain goods to a person. So what they are saying is that unless and until you make this amount of payment, we will not deliver these goods to you. Now this payment is not legal, it's illegal. They are not entitled to charge this amount. So the person is not having any other way, right, to get those goods. So he might make the payment, he may take those goods, and later on what he can do is that he can file a case for recovery of that amount that was charged from him. So that would be like coercion only, right? That what happens is that this person is like the railway company, right? They are not entitled to that particular amount, but still they charged it from the person. So he can later on file a case that I was in need of those goods very urgently, so I had to pay, but it's not legal, so I should be like getting that particular amount back. So okay, so this was the last section. Any doubts on the sections part? Section 72, is it clear?
Yes.
Okay. So section 72 is basically saying that by some kind of a mistake or under coercion, I am making some kind of a payment or I am delivering something. But that is not like my responsibility. That is not a liability on my side. So later on, I can again ask for refund or return of those goods or refund of that particular amount. So we have this case also. What happened in this case basically is that this government of Madhya Pradesh, right? They were like allotted contracts for manufacturer and sale of liquor by auction, and a certain amount of fees was charged by government. So government started charging that particular fees, and this person, right, Mahavir Kishore, he also was paying that particular amount. Now later on, what happened in 1959, some judgment of MP High Court came, and in that particular judgment, High Court said that this amount that government of Madhya Pradesh is charging, right, that is not legal, that is illegal from their part, and they should not be charging that amount from these people. So now what happens is that it was basically like just a High Court decision, right? So the person was not aware that this decision came, and even after that decision, government was collecting the money. So Mahavir Kishore was not informed or not notified about that particular government order. He was also paying, and government was also accepting that particular payment. So they were still paying that, like accepting that payment. Later on, again, some other case was filed, and again, that in that case, in 1961, again, court held that this charges were illegal, right? So MP government do not have the authority to charge these fees, and they should not be doing it. So later on, what happened after the second decision came, then Mahavir Kishore came to know about this decision. So what he basically said is that I was not aware about this decision. Department also did not inform. They were also accepting the payment whenever I was paying. So what happened is that this entire duration, right, I was making the payment which is not legal. So I should be, like refunded, right? All the payment that I have paid, that should be refunded to me, because I was not aware about the judgment, and department also did not bother to inform me, or, they were just accepting the payment. So I should be returned or refunded that particular amount. So this case is even relevant for CPC, okay? So in this case, what happened, basically a case was filed for recovery of money, but then again, government of Madhya Pradesh said that this limitation period has already is already over, right? It was like in 1959, and now you are filing the case. So this 3 years limitation is already over. You are not entitled for this, like the previous amount which you have paid, because we have already used that amount and all of that, they said. But what court said is that this amount that was paid by the person, right, it was by some kind of a mistake. So when it's a mistake, we cannot put limitation on when it was paid, right? If first payment was made in 1959, the person came to know about his mistake in 1970, we cannot say that limitation period is over. Because like that, in most of the cases, only limitation period would be over, right? Might be the person would come to know about after 4 years, 5 years about his mistake. So what was said is that whenever some kind of a mistake takes place, from when limitation period would run, it would run the moment the person comes to know about his mistake. So if the first payment was made in 1959, he comes to know about his mistake in 1970. From 1970 only we will be counting limitation period. From that time, he will have 3 years to ask for return or refund of that particular amount. So in this case, it was said that under section 72 of Indian Contract Act, the person is entitled to get refund of that particular amount because he was paying it by some kind of a mistake. So limitation period and all would not be applicable. It will be applicable only from the time when he came to know about his mistake. So from that time only we will be calculating the calculating the limitation period, and accordingly he will get the time. So we cannot give unfair advantage to government of Madhya Pradesh that just because the person was not aware about this High Court decision, he should not be getting refund of that money, because government was also taking it, right? They should have also refused to take it. My internet just got disconnected. This case we completed, is it?
Yes, ma'am, it's done.
So in this case, what happened is basically that they, like this person was not aware about this government rule, and he was still paying for it. So later on, when he came to know, he filed a case saying that it should be returned to me. So in this case, the section 72 was applied, and it was said that someone else should not be getting. So in this case also, this principle was applied. Okay, the principle of unjust enrichment was applied, and basically what court held is that government should not be taking like unfair advantage or unfair benefit out of this person's that the person was not aware or the person's mistake. So this principle was applied, and these three grounds were held that in this case also government is taking some kind of a benefit, and it is at the expense of the other person. The other person is not aware about the the High Court order, so he is paying it. So it's at the expense of his expense. Government is enjoying some benefit, and it's unfair for the other person. Just because he was not having knowledge of that government order, government continued taking that particular charges from him. So the same principle was also applied in this case also, and it was said that because of this principle, unjust enrichment, the concept of restitution, this thing applies, right? That whatever benefit they have taken, it should be restored back to that particular person. Someone should not be taking unfair advantage of someone else. So same applied in this other case also, where tax paid by mistake of law is refundable. So in this case, the main question is whether a tax paid under mistake of law is refundable or not, based on the provision of section 72 of Indian Contract Act. What basically happened in this case, the respondent was a registered firm, okay, and they paid sales tax in respect of some kind of forward transactions. That means already these transactions has not taken place, but they paid the tax in advance, right? They paid the tax previously, saying that whatever like sales we would be doing in the coming years or months or so, we are paying the tax now only. So it was like some kind of taxes paid for forward transactions, that whatever transactions we will be doing in the coming days, for that we are paying this tax. So in some kind of court judgment came, Allahabad High Court. In another case, it was held that charging of these kind of taxes on forward transactions is not legal. So in this case, court said that it's not something which is legal. So if it is not legal, the person, like the registered firm, they said that it should be refunded to us. If it is not legal, you should repay it to us. So in this case also it was. So in this case also, authorities said that it's like a mistake of law from the other person, and we are not bound to repay it. Whatever amount was paid to us, we have already used that amount and all of that, like those grounds they mentioned. But court held that you are entitled to refund that particular amount to the other person, because like
I mean,
it is
the
not,
copy it says they are not entitled. Just go a little
which one?
up. It was
Right,
contended that the sales authorities.
Yeah.
Okay. Sales authorities contended that
sales,
they were not allowed for a refund.
Yeah. Just because they said that we have already used that amount, right? Whatever amount was paid, we have already used that amount and all of that. And it was not like we were asking for it, you only came forward, it was your mistake, and all of that was argued by that particular sales authority. So in this case, court said that whatever mistake we are mentioning under section 72 of the Indian Contract Act, it's not just about mistake of fact, but it would even include mistake of law also, because if it's a mistake of law, someone else should not be gaining like unfair advantage and the other person is suffering because of that particular situation. So it depends on us whether we want to apply or not. So it's like court's discretion. If they want, they can even apply it to mistake of law also, if the situation is such that one person is gaining some kind of a benefit and the other person is losing out on that. And also same that limitation thing, right? It should apply from the time when the person comes to know about it. If he comes to know about the situation now, it would apply from now only, right? Limitation would start running from now only. From now he will have 3 years, not like 3 years already is gone, now he is coming, and all of that should not apply. So same only basically was held like in these two cases. So it is liability of person to whom money is paid or things are delivered under mistake or under coercion. Maybe the authorities are binding the person to do it, or maybe it was because of some kind of a mistake. And this mistake here is not just limited to mistake of fact, but even in case of mistake of law, if court feels that it would be unjust or unfair for the other person, court can apply this principle of unjust enrichment, and accordingly they can ask for refund of that particular amount. So this was all about quasi contract. So is this part clear?
Yes, ma'am.
These 5 sections. So in all of these cases, like provisions, right, what we have seen is that there is no like a formal contract or anything like that. But even then there is some kind of a relation between the two persons, and one is bound to repay or refund the benefits. So next thing that we have is chapter 6 that talks about consequences of breach of contract. Only just 3 sections are there that we will just see what these sections are. So it is about consequences of breach of contract. So we all know, right, that when there is a contract, there are 2 parties. One makes an offer, one gives his acceptance. There is a promise between the parties. So they are legally bound to perform or fulfill that particular promise, whatever they have made. If they do not fulfill those promises, if they violate the contractual obligations or anything like that, what will be the consequences for such breach of contract? So there are basically 3 provisions that we have: section 73, 74 and 75. So we will see these provisions. Okay, so we will see these provisions. First is section 73. It is compensation for loss or damage caused by breach of contract. So sometimes what happens is that like when there is breach of contract, right, one person violates his contractual obligations, the other person is suffering some kind of a loss. So in that case, we should compensate for the loss or damage that the other person has suffered. So when a contract has been broken, right, there was some kind of a promise, that promise was broken. The party who suffers by such breach is entitled. If there are 2 parties to a contract, one of them violates the contractual obligations, the other party suffers as a result of it, he is entitled to what? He is entitled for compensation for any loss or damage that he has suffered. So if there are 2 parties, one party violates his contractual obligations or liabilities and the other party has to suffer because of it, he is entitled, or like he is entitled to get compensated for this. Now what would be that particular compensation, right? Like how much we will compensate and all of that question comes. So in this provision only they mentioned that which naturally arose, right, in the usual course of thing, because of that particular breach, for that only that person should make compensation when they made the contract to be, or whatever they knew to be the likely result of that particular breach. Take for example, when making that particular contract, they knew that okay fine, if I violate this particular contractual obligations, this would be the possible loss or harm that the other person suffers. So for such possible harm or loss, the other person should be compensated. And it should be what? It should be something that is the natural outcome of that particular breach. It should not be something which is like very remotely related to my breach. It should be something which is the natural result, or usual course of things, right? Which is a natural result of that particular thing. We will see one case that will make the things clear. So basically section 73 says whenever there is a promise between two persons, whenever there is a contract between two persons, both of them should perform their contractual obligations. Both of them should perform whatever things they have promised. If one person is not performing it and another one is suffering some kind of a loss, he should be compensated for that particular thing. And what would be that particular compensation thing? It will be to the extent what is, like the natural outcome of it. It should not be something which is too remote. So for that, we also have a principle, remoteness of damage. So what is this principle? Anyone wants to explain remoteness of damage? Remoteness of damage. Anyone?
Those damages which can be predicted in the natural course of actions. So all the damages the party is liable to pay for which he is guilty of.
Yeah, which can be predicted and also which is like the natural outcome of that particular situation, right? So for all those damages, parties can ask for damages, right? So that is what is called as remoteness of damage. That means whatever damages we are asking, right? Whatever compensation we are asking for the damage, it should not be like very remote, right? It should not be too remote. It should be something that has happened because of this situation. So party who has broken the contract is liable to pay such damages which are proximate consequence of such breach, which we could foresee that, okay, fine, if I'm doing this thing, this would be, like a possible result of it. For that only I'm liable. I'm not liable for something which is like too remote or something like that. So party at guilt is not liable for every possible remote damages or losses that is incurred by the other party. So one good example may be like, take for example, one person was like there is some kind of an accident that takes place on a road. Okay, one person was guilty, might be he was driving negligently or something like that. So what would be his liabilities? He will be liable to pay compensation to the other person to repair his vehicle or maybe for the medical expenses that he might incur. During that situation only, what might happen is that maybe some like a pregnant lady was walking, okay, by the side of that particular road, and suddenly by seeing that particular accident, she just lost her consciousness. She just fell there, and then maybe she was suffering from diabetes also. So because of that, it took a long time for her injuries to get healed or something like that. Seeing her situation, her family members got sick, they also were admitted to the hospital and all of that, right? So now this person, right, who was guilty of driving negligently, he would be liable to pay for the expenses to this other person only, right? That this person, whatever damages were caused to his vehicle, for that he will be paying. He will not be liable to pay expenses for that pregnant lady who was also suffering from diabetes, and because of that it took long time to heal all her injuries. Then her family members were, were also sick because of this situation and all of that. Those are what? Those are very remote causes. Obviously, if she is walking on the road, she is also responsible for her own self, right? If her family is so much like concerned about her, they should not allow her to go out only. If that situation is so, what to say, so like the situation is such, then they should be taking care of those things. Now this person who is driving negligently, we cannot make that person liable for all those other things. Why? Because it is not something that has directly resulted because of that particular situation. So he should only be made liable for whatever is the proximate consequence of that particular breach or whatever naturally arose because of that particular situation. For that only we should be making the person liable. Maybe some accident took place, one person was, he was so interested in seeing that particular situation that he did not even realize that he stepped inside some kind of a manhole or something like that. He injured his leg. Now this person who was driving negligently, he will not be liable to compensate this person. Why? Because if I'm walking on the road, I also have some kind of a responsibility towards my own self. So I cannot see that because of this situation, because of this accident only it happened. So whatever I'm asking, right, compensation or things like that, it should not be something which is too remote also. It should be something which is related. So there is one case also related to this. What happened in this particular case is, because of some kind of negligence of railway company, this plaintiff and his family like got down in some wrong railway station, and there were no hotels or anything nearby, and because of that they had to walk a long distance in rain, and plaintiff's wife caught cold, and the defendant had to incur medical expenses. So they claimed for that particular medical expenses also. So what was said is that, you know, like the wife falling sick, husband incurring medical expenses, those are like two remote consequences. That is not directly related. Might be wife was already not feeling well, and then because she was working in, you know, like a rain, she fell sick or something like that. If she is, you know, like if her immunity is not that strong, might be they should have waited for the rain to stop or something like that. So for every single thing, we cannot make the other person liable. That is the main principle, that we should also look at the remoteness of damage. How closely is it related to that particular situation, and for that only we should make the person liable. We cannot, because one situation happened, we cannot just bring all our other problems and then connect it to that problem and then ask for like compensation for that situation basically. So is this clear, section 73? Section 73, is it clear?
Yes, ma'am.
Vijay, is it clear?
Yes, ma'am.
Okay. Okay, fine. So next we have section 74. So what is section 74? It is about compensation for breach of contract where penalty stipulated for. That means while making the contract itself, we have mentioned the penalty. That okay, fine. If you know, like either of the parties violate the contract, maybe 1 lakh would be the amount of compensation that should be paid. Or we have mentioned a certain guideline to calculate the thing. Might be we have mentioned that if any of the party violate the contract, you will have to pay 5% of the monthly profit that I make from the business, or 10% of the monthly profit that I make from my business, right? So I have not mentioned like a proper amount, but I have mentioned how it will be calculated, right? So whatever is my monthly profit, you know, like the average monthly profit, from that 5% we will count. So like that, if like penalty is stipulated for, right, we have mentioned the penalty, that amount should be paid. So what happens in this case is that when in a contract is broken, so a good example would be like a bond agreement. Okay, so what is bond agreement? Anyone? What is bond agreement? So what is bond agreement? Basically, before joining a company or something like that, they might say that, okay, fine, you need to sign on this bond agreement that you agree that you will not leave us before 2 years, 3 years or something like that. Okay. So based on that particular bond agreement, you are making a commitment that I will stay in this company at least for 3 years, at least for 2 years or something like that. So now take for example, A is a person, okay? He is employed by B for a job as IT professional. Now for that particular job and for that particular job role, what happens is that they need some kind of a training, okay? They need some kind of a training, which is for like 6 months. 6 months, and it's like a very expensive training. It is for 2 lakhs rupees, okay? So for the type of work that he will be doing, he need to know that particular thing that he will learn in that training. duration of that training is 6 months and the expenses are like 2 lakhs rupees. So basically company is employing him, but company will be paying his salary also, but company will not be gaining any benefit or any work from him. But company will simply be investing 2 lakhs rupees on him to get the training thing done. So what company will do, obviously for their own like safety or security, they will ask him to sign a bond agreement saying that you make a commitment that you will not leave our company before like 4 years or 5 years. If you do, you will have to pay a compensation of maybe like 4 lakhs rupees. 4 lakhs rupees. So what happens in this bond agreement itself, they are saying that you will have to pay 4 lakhs rupees to us if you are leaving before 4 years, 5 years or something like that. Why is it mentioned? Because obviously company is investing 2 lakhs rupees. Also they are paying salary to the person. So they have mentioned that you should be paying this amount of 2 lakhs, like 4 lakhs rupees. So in that case, what happens? He will have to pay that 4 lakhs rupees no matter whether company has actually suffered that amount of loss or not. Might be the company is having some kind of an association with some institute, okay, that is providing this training. So that particular institute said that we will be providing this training free of cost for 5 of your employees. So might be the company did not even pay for A's training. It was for free only that was offered to the company. But even then company is entitled to ask for this 4 lakhs rupees. A cannot say that my admission was anyways free in that institute because you were getting some kind of an offer or something like that. So A cannot say that. No matter whether company has actually suffered 4 lakhs rupees ka loss or not, they are entitled to claim for that particular compensation. Why? Because it was mentioned in that particular agreement, bond agreement itself. Is this section clear?
In case the damage is more, also he'll still be liable to pay the what is stipulated in the bond agreement.
See, if damages are more, again, we have certain provisions under like a specific relief act also, right? Sometimes what happens, parties claim for something, might be they are not aware that I can claim this much amount also, or might be they have mentioned something, but actually damages were like too high from what they are claiming. So in such cases, even courts allow that you can make changes in your plaint. You can just increase the amount that you are asking. That provision is anyways there. This is like in general situation where expenses are not even incurred, then also he can ask. Might be it's like 5 lakhs loss that he have suffered, then also they would be asking for 4 lakhs. But there might be a situation where of loss because the person left. Might be in that case, like court also has some kind of discretion. When we study specific relief act, you will get these provisions also, that even court can ask the person that you are asking for 4 lakhs rupees compensation, that is too less for you. You make changes in your plaint and you ask for 9 lakhs rupees. You ask for 11 lakhs rupees. There are cases like that also. Like it depends on court's discretion.
So that is covered under specific relief.
Yeah, specific relief act that is covered. So you will get the provisions also where court can ask that you make the changes. So if situation is normal, if they are not suffering any loss also, they can say that 4 lakhs rupees you pay. If they are suffering around 4 lakhs, then also they can say that, okay, fine, you pay 4 lakhs rupees. Or if in any case, court might feel that, okay, fine, loss was like 6 lakhs, but company was also under some kind of a fault. Because of that only loss was that much. Court might say that, no, you are entitled to 4 lakhs only because you were also under fault. So it depends on the situation basically. But whenever it is stipulated for, that would be, like what the parties are entitled to, whether or not they have actually suffered that amount of loss. So the best example for this to remember is bond agreement. So this is again based on a principle called quantum merit. This basically means as much as is deserved or what one has earned. What one has earned. Basically, this was like a very expensive training that he received, right? After 6 months, if he is leaving this company, he should be paying for this 2 lakhs rupees, like the training amount, right? And also he was gaining salary, so he should be paying 4 lakhs rupees. Why he should be paying? Because what he has earned, right? He should return what he has earned, or as much as is deserved. As much as this IT company deserves, that much he should pay. If IT company deserves 4 lakhs rupees, he should pay 4 lakhs rupees only. So this is called as quantum merit. Whatever is the amount that should be returned or refunded to that particular person who is guilty of breach. So whoever is violating, that person cannot ask for this particular principle, but whoever is suffering because of the breach, that person can ask for it. So it basically is like we want to bring that person, right? We want to take that person, IT company, to the position where it was before entering into the contract. Before investing on ACE training, it was having some money, right? It was having some money. So we should again, you know, like bring that particular IT company back to its original position. So basically whatever it deserves, whatever is the amount, that amount should, again, we should pay to that particular person. So is this section clear? Section 74, any other example or something you want? Now, the previous two examples, right? These are like when I'm violating a contract, I am responsible to pay. But in this case, what happens? Party rightfully rescinding contract entitled to compensation. I am only putting an end to the contract, but I am only entitled to compensation. Other cases, someone else is breaking the contract, so I am entitled because I am at a losing position. But in this case, what happens? Party rightfully rescinding contract entitled to compensation. I am only putting an end to the contract, but still I am entitled to compensation. Why? Because I am putting an end to the contract. How? I am doing it rightfully. Right? I am right at my position to put an end to the contract, so I am entitled to compensation. So one good example would be, one person made a contract with another to perform for continuous 10 days at maybe like 5 o'clock at his place to sing, right? So what happened is that after the 4th or 5th day, he willfully did not go there, did not perform. So the other person can say that, relying on your promise, I, you know, like sold tickets and everything. Now you are not coming, means I'm suffering loss. So what he can do is that he can put an end to the contract. He can say that, okay, fine, from tomorrow you don't need to come and perform. We will put an end to the contract. Apart from that, whatever loss I have suffered on that 5th day, because you did not come and you did not perform, for that also you need to compensate me. So accordingly, the person can ask for compensation. So here, owner of that particular event, he is putting an end to the contract. But how he is doing it? He is doing it rightfully. So he is again entitled to compensation even after putting an end to the contract himself. So is this part clear, what is rightfully rescinding contract? Any doubts on these sections that we discussed today? Anyone, any part to be repeated? Is it clear, these provisions?
Yes, ma'am.
Okay. Neha and Vijay, is this part clear? Any part to be repeated?
Yes, ma'am.
It's clear.
Okay. So this is basically about quasi contract and also consequences for breach of contract. So this was like the last part for essentials of contract, you know, like the general provisions. So next class we can continue with the specific types of contracts. Okay, now there are some questions. Okay, some questions are there that you can try to answer from previous whatever we have discussed, right? From that part only, these are some of the questions that you can see. So consent is defined as that portion said to be consenting upon the same thing in the same sense.
2 or more.
Yeah, it is 2 or more persons. So Option A. Two or more persons are said to consent. Question number 2.
D, ma'am.
This
Above.
all
All
of
yeah, all
yeah.
of it.
Of all. Which section defines undue influence?
It is 16, ma'am.
Section 16. Yeah, so see, for these kind of questions, right, you can try to remember the sections for the important things. Next is
I think it's void, ma'am.
yeah, it is void. Agreement without consideration is void, but there were certain exceptions that we saw, right? Out of
Yes, ma'am.
natural love and affection, trust, and all of that. Next is
D, ma'am.
all of the above. So it should be in writing, it should be registered under law also, and the parties must stand in near relation to.
B, 6, B, ma'am. 11, section 11.
11th section.
11. Yeah.
Uh, 18.
18. Under which act?
Indian Majority Act.
Yeah, Indian Majority Act.
This is A, ma'am. Is void ab initio and cannot be rectified.
Question number?
8. It's minor's agreement is void ab initio
Yeah.
and cannot be rectified.
Yeah. Minor's agreement is void of initio and cannot be rectified. A, right. An agreement to extend the period of law of limitation prescribed under the.
I think it's illegal.
It's illegal. So it is under section 23, right? It says consideration and object of contract should be lawful. And
Yes,
it says that it should not be something that if it is permitted, it would defeat the provisions of any law.
yes.
So it will be legal.
Yes, ma'am, it is. It's an invitation to.
Yes,
It's
it
an
is.
invitation.
Yeah, it is invitation to offer only.
Void agreement.
Which of the following correct meaning? Yeah, which section defines void agreement? Section 2G of the Indian Contract Act. Try to remember the sections for definitions,
Yes,
okay? That is like very common question. Or binding contract.
agree upon the same thing in the same sense.
Okay. Which section defines this, like consent?
A free consent, I think, is section 13, ma'am.
Consent is section 13. Yeah, consent is 13 again. Yeah. So again, it is based on the maxim consensus ad edim, right? Meeting of the minds. So it is option 3. agree upon the same thing in the same sense also. When goods are displayed in a shop.
The customer, ma'am.
Customer, yeah. So we discussed one case similar to this. Anyone remembers the name?
The Boots Cash Chemists Limited versus Great Britain.
Yeah. So Pharmaceutical Society of Great Britain versus Boots Cash Chemist Limited. So like prices of drugs were displayed, right? So it was said that it was basically invitation to offer and they are inviting it from the possible customers. Question number 14.
The promise is valid.
This promise is valid because it is properly made, right? So it will be valid, it is registered and all of that. So otherwise, normally if we are saying that will not be like a binding thing, but if it is properly in written and signed and everything format, then it will be binding on the parties. Okay, so these were some of the questions. So do you want to discuss like more questions from the general principles part, because the general provisions part is like over. Okay, now we will move to the specific types of contracts. So if you want to discuss more questions or of this type for that part, we can do that in next class.
Yes, ma'am, it will be helpful.
Okay. So fine then, for the general provisions part, I will try to find out some more like these kind of questions and then we can discuss that. And in next class, we will continue with the specific types of contracts that we have, right? Indemnity, guarantee, bailment, pledge and all of that. So basically there what you need to know is that, you know, like the liabilities of bailee, which section talks about the liabilities of bailee, which section defines bailment and all of that, right? For these kind of things, right, try to remember the sections. Basically, which section defines bailment, which section defines pledge, which section defines guarantee and all of that, right? For that part, try to remember the sections. Basically that kind of questions they are asking. And also which section talks about responsibilities of bailee and things like that. So fine, then next class we will start with the specific types of contracts, and also we'll see some like questions relating to that. So any doubts from the this general principles part, or anything you want to be discussed or something like that for the general principles part?
And this thing, what about the indemnity contracts, bailment and pledge? Is it the next?
Yeah.
Okay.
Indemnity, guarantee, pledge, bailment, that part. Okay, so fine then. We are ending this class here. Okay, so next class we will continue with the specific types of contracts, and also we will see some cases if we get. Okay.
Okay, ma'am. Thank you.
Yeah. Okay. Thank you. Bye bye.